Okay, let's unpack this. Imagine you're a federal employee, maybe we can call you Sarah, and you've sustained an injury on the job. Your compensation, getting the support you need, it really hinges on a medical opinion. But what happens if the doctor giving that crucial second opinion isn't even a specialist in your specific injury? It sounds like a nightmare, right?
It's a common fear, and unfortunately, yeah, it's a real possibility that can feel incredibly unfair.
So today we're diving deep into the Office of Workers' Compensation Programs, OWCP, and their policies under the Federal Employees Compensation Act, FECA. Specifically, we're looking at these second opinion disputes and, importantly, what you can actually do if you think an unqualified medical opinion is impacting your claim.
And what's truly insightful here, I think, isn't just knowing the rules on paper. It's realizing how often these guidelines, which are actually quite detailed, get misunderstood or maybe even misapplied. Our goal today is really to give you not just the facts, but the strategic clarity needed to navigate this, turning what seems like a confusing pile of documents into, hopefully, a clear pathway for action.
Right, turning confusion into some kind of control.
Exactly.
And to do that, we've pulled out the core insights from our source material, mainly excerpts from OWCP second opinion disputes under FECA. We're aiming to give you the key takeaways you need pretty quickly. So let's start with the foundation. What's OWCP's core stance on these second opinions? This is where it gets really interesting.
Well, the fundamental policy is that OWCP generally requires these second opinion examiners to be specialists in the appropriate field of medicine for the specific injury being evaluated.
So they actually contract with board-certified specialists for this. They're not just picking any doctor?
Correct. They aim for the right fit. So if our hypothetical Sarah has a knee injury, the second opinion should typically come from an orthopedic specialist who deals with knees, not, say, a hand surgeon or a dermatologist.
Okay, that makes sense. Does that mean their opinion automatically carries more weight than...
It certainly should. Both OWCP and the Employees Compensation Appeals Board, that's ECAB, they consistently prioritize opinions from physicians who have specialized training in the relevant field. So, all other factors being equal, a board-certified specialist's opinion usually holds greater probative value.
Probative value?
Yeah.
Meaning it's more credible, more convincing.
Essentially, yes. It holds more weight in the decision-making process. So like you said, a treating orthopedist's detailed opinion on a knee condition shouldn't just be tossed aside based on what maybe a podiatrist thinks about it.
Right, so they really are looking for the most qualified expert. And there's even hierarchy. Board certified is better than non-board certified, and maybe a professor is even higher.
That's generally the principle. A board-certified specialist in the field is preferred. An acknowledged expert or professor in that specific area might carry even more weight, though that's less common in standard second opinions. It seems quite clear on paper.
It does seem clear. Which leads to the big question. Can an unrelated subspecialist actually overrule a qualified treating physician?
Well, there isn't an explicit rule saying absolutely not, but, and this is key, it deviates significantly from OWCP's standard practice and their own quality guidelines. Using a mismatched specialist, it really makes their opinion less credible. It could even trigger the need for more clarification or potentially what's called a referee examination.
A referee exam, what's that?
That's where OWCP brings in a third, impartial specialist to resolve a conflict between the treating doctor and the second opinion doctor. Crucially, OWCP's own manual leans heavily towards relying on the relevant specialist when opinions differ.
Okay, so the system itself kind of acknowledges the problem with mismatched expertise.
Yes, it recognizes that expertise matters.
Got it. So let's make this practical. What does this mean for you if you find yourself in this tricky spot? Let's say OWCP denies or cuts off benefits based on an opinion from a doctor who, doesn't specialize in your condition. What's the first move?
Okay, the very first thing you should do, and do it quickly, is request clarification or reconsideration directly from OWCP. Put it in writing to the claims examiner. You need to clearly state the specialty mismatch. For instance, Dr. Smith is a hand specialist and does not treat knee conditions like mine. Explicitly point out the lack of relevant expertise.
And you mentioned citing policy.
Yes, absolutely. Cite OWCP's own policy on using appropriate specialists. You can often find this on the Department of Labor website, DOL.gov. Politely ask them to either disregard that opinion, give it less weight, or ideally, schedule a new exam with the right kind of specialist.
And getting that objection documented is key for later. Right?
Crucial. It forms the basis for potential appeals if needed.
Okay, step 1. Object in writing. What's next?
Step 2 is submitting strong supporting medical evidence from your side. Work with your attending physician, or maybe another specialist in the correct field, to directly refute the flawed second opinion. This counter-report needs to explain exactly why the other doctor's assessment is flawed, perhaps because it's outside their expertise, and provide solid medical reasons for your doctor's findings.
So highlight your doctor's qualifications too, like if they have special training.
Definitely. Emphasize things like fellowships, years of experience with that specific condition, board certifications in the relevant specialty. Remember, OWCP's own framework gives more weight, more probative value to the more qualified specialist.
Makes sense. Provide better evidence from a better source. Is there a third immediate step?
Yes. Step 3. You can formally invoke the conflict resolution process. This is based on a federal law, 5 U.S.C. Section 8123A. Basically, if there's a clear difference in medical opinion between your doctor and OWCP's doctor, and importantly, if their reports are considered of equal weight and rationale otherwise.
Equal weight, meaning both reports seem well-reasoned on the surface?
Exactly. If they're both rational but just disagree, OWCP is supposed to declare a conflict, and when they do, the law says they should refer the case to a third impartial specialist.
The referee physician you mentioned earlier.
That's the one. And critically, this referee must be qualified in the appropriate specialty and have had no prior involvement. This is a powerful mechanism to neutralize an opinion from an unqualified second opinion doctor.
Wow, okay. Object in writing, submit counter evidence, and invoke the conflict rule if needed. That's a very clear roadmap. Do people often miss that third step, invoking the statute?
I think sometimes they do. They might ask for reconsideration, but not specifically point to 5 U.S.C. Section 8123A and the requirement for a referee exam when there's a conflict of equally weighted opinions. Formally invoking it adds teeth.
Good tip. Now, those tips are great for trying to fix things early, but what if OWCP digs in its heels and issues a final unfavorable decision anyway? That's when formal appeals come in, right?
Yeah, that's exactly right. Once there's a final decision, you move into the formal appeal stages. And there are a few different paths you can take.
Okay, what are the main ones?
First, you have the option to request either an oral hearing or a review of the written record. But you have to act fast. The request must be made within 30 days of that final decision. Very tight deadline.
30 days. Okay. What happens at a hearing?
At an oral hearing, you get to testify, explain your situation, present arguments definitely highlighting the specialty mismatch, and you can submit new supporting evidence at that stage.
And the review of the written record.
Similar goal, but it's all done on paper. The OWCP hearing representative reviews the existing file, plus any new written arguments or evidence you submit with the request. No live testimony.
Got it. What's the next appeal option?
The second option is reconsideration by OWCP itself. You have longer for this, up to 1 year from the date of the merit decision. But crucially, reconsideration isn't just asking them to look again. You must submit new evidence or a new legal argument that wasn't previously considered.
So like a detailed argument about why the second opinion was flawed because of the specialty issue, or maybe that new report from your specialist.
Precisely. You can technically request reconsideration multiple times, but each request has to bring something genuinely new and relevant to the table.
Okay, hearing, reconsideration. Is there a higher level?
Yes. The third main avenue is an appeal to the Employees' Compensation Appeals Board, ECAB. This is an independent board within the Department of Labor, kind of the highest administrative appeal level.
How long do you have for that one?
You have 180 days from OWCP's final decision to file an appeal with ECB. But here's a really important distinction. ECKB's review is strictly limited to the evidence that was already in the case record when OWCP made its decision.
So you can't add new medical reports or arguments at the ECBP stage?
Correct. All the evidence showing the specialty mismatch, your doctor's rebuttal, everything, it must have already been submitted to OWCP and be part of the record ECK reviews.
So you need to build your case before you get to ECD?
Absolutely. If the evidence is there, ECKB can definitely reverse or remand OWCP's decision if they find the second opinion was given improper weight due to the specialty issue. They've explicitly held that examiners must use an accurate background and the proper specialty.
It sounds like ECP is often the last stop in this process.
It often is, administratively speaking.
And throughout all these appeals, hearing, reconsideration, ECAB, you mentioned citing the rules.
Yes, always. Citing the specific regulations like 20 CFR Section 10.321B, the Statute 5 U.S.C. Section 8123, or relevant sections of the OWCP Procedure Manual. it really strengthens your argument.
It shows you know the rules they're supposed to follow.
Exactly. It signals to the decision maker that, hey, maybe procedure wasn't followed correctly here. It adds significant weight to your appeal.
Okay, that clarifies the appeal pathways. Now, let's zoom out a bit. We've talked about the rules and steps, but what about the legal backing? The guidelines and precedents that really underpin all this?
Right. Let's look at the foundation. The OWCP procedure manual itself, specifically Section 2-0810, which deals with evaluating medical evidence, is quite explicit. It directs OWCP staff that differences in medical opinion should often be resolved by weighing the qualifications of the physicians.
So the manual actually says that.
Yes. It essentially states that if a treating specialist disagrees with an OWCP-referred examiner, and again, all other factors in their reports are equal, the opinion of the specialist in the actual field of the claimant's injury will usually carry greater probative weight.
So an orthopedic surgeon's opinion on a broken bone just carries more weight than, say, a general practitioner's opinion on the same break, assuming both reports are otherwise well-reasoned.
That's the principle. The manual even says OWCP should seek clarification or potentially a new exam if a second opinion report seems inadequate or looks like it's outside the doctor's core area of expertise.
So the internal guidance supports challenging mismatched specialists.
It does. And ECKB case law powerfully reinforces this.
Are there specific cases we should know about?
Definitely. A fairly recent one, LTV U.S. Postal Service from November 2021, is a perfect example. In that case, OWCP had terminated benefits for a neurological condition, spasmodic torticollis, based on the opinion of an orthopedist.
An orthopedist for a neurological condition.
Exactly. And ECK found that opinion deficient. They stated the orthopedist was not qualified to render an opinion on that specific neurological disorder. Consequently, they reversed OWCP's termination.
Wow. That's a clear precedent. If the specialty doesn't match the condition, ECKB won't give the opinion weight.
It's a very strong statement from the board, and there are older foundational cases too. James P. Roberts from 1980 confirmed that where there's a genuine conflict between equally rational opinions from the treating doc and the second opinion doc, OWCP must refer the case to an impartial referee examiner.
The impartial specialist again.
Yes, who must be a specialist in the relevant field. And even earlier, Lee R. Newberry in 1983 established the core principle that physicians with specific training and experience in a field have greater probative value on questions within that field than other physicians.
So this isn't a new idea. It's been baked into the system for decades.
Precisely. These aren't loopholes. They're established principles designed to ensure fairness based on actual expertise.
So if we boil it all down, the overarching message seems pretty clear. OWCP's own policies and the rulings from ECCAB do not support blindly accepting a second opinion from a doctor with an unrelated specialty, especially if it contradicts a qualified treating specialist.
That's the key takeaway. The system allows and even expects scrutiny of the examiner's qualifications relative to the injury.
And by understanding these rules, these precedents, and crucially, by providing strong medical evidence from the right kind of specialist.
Claimants have a very real chance of getting an improper decision reconsidered or overturned. It's about leveraging the system's own standards to ensure a fair evaluation based on proper medical expertise.
So what we've really seen today is that while this whole OWCP process can seem incredibly complex, maybe even intimidating, you're absolutely not without recourse. Knowing these specific policies, these appeal routes, these precedents, that knowledge really is your power here.
It truly is. And, if we connect this to the bigger picture, it really boils down to a fundamental principle: fair evaluation based on genuine expertise. Understanding these details isn't just about trying to win one specific claim. It's about upholding the integrity of the medical assessment process itself within this federal system.
That's a great point. And maybe a final thought for you listening. Consider this. How might understanding these kinds of specific procedural details, the rules of the game, empower you, not just in a workers' comp scenario, but maybe in navigating any complex system where expertise and evidence are crucial? What other areas of your life, maybe dealing with insurance or healthcare or even contracts, might benefit from this kind of deep dive into the underlying rules and procedures? Something to think about. Thank you for joining us on this deep